Good evening. I'd like to call to order this meeting of the Board of Education. Board members have been in session this evening starting at 6 o'clock. We had two closed session topics listed on our agenda: employment of employee and collective negotiations. We did not address anything on employment of employee. We did have discussion on collective negotiations. Mrs. Walsh, can you please call the roll?
Ms. Conroy?
Here.
Mrs. Droney?
Here.
Mr. Collins?
Here.
Mr. Kalquist?
Here.
Mrs. Ostashik?
Here.
Ms. Hirsch?
Here.
Mrs. Davey?
Thank you. We have 7 board members present, none absent. Please stand and join me for the Pledge of Allegiance. Our next item on our agenda is public comment. We have 4 individuals who have signed up to address the board. When I announce your name, if you could come up to the microphone and turn it on and start with your name and address. Public comment is limited to 3 minutes. There is a light up there, and when it turns yellow, that means your time is almost done. We have a very significant agenda tonight. We're going to be very diligent with our time management. Our first speaker is Lisa O'Halloran.
Lisa O'Halloran, 180 Lawndale. I would like to discuss the policy change that is up for adoption regarding public comment. Of particular concern to me are the following proposals. The board president may shorten or lengthen an individual's opportunity to speak. The president may deny an individual the opportunity to address the board on the same subject within 2 months. The board president shall have the authority to determine procedural matters regarding public participation not otherwise defined in board policy, and speakers must use respect and civility towards others. Particular issues I have are: 1, how is respect and civility towards others objectively defined? Who gets to define respect and civility towards others? My respect and civility might be different from your respect and civility. This is the kind of vague language that censors people's speech. There will be no way to keep this content neutral. If the board president may shorten or lengthen an individual's opportunity to speak, how will this affect subjects unfavorable to the board president? Does this give unlimited discretion to unduly shorten unfavorable speech and freely lengthen favorable speech? The new policy will likely result in impermissible viewpoint discrimination. 3, if the president may deny an individual the opportunity to address the board on the same subject within 2 months, then how will the board define same subject? What if there is more information, new questions on the same subject matter? Is that readdressing an issue? What if the issue simply was not answered or resolved? Does this give an opportunity to indiscriminately curtail unfriendly opinion? Additionally, there is on occasion an inherent value to readdressing the board on the same matter. In other words, sometimes a subject matter is so important it bears repeating. 4, if the board president shall have the authority to determine procedural matters regarding public participation not otherwise defined in board policy, does this give them unlimited procedural safeguards to limit all unfavorable speech? How in particular will this be kept content neutral? 5, does this open the BOE up for costly lawsuits stemming from First Amendment violations? I understand that this was in a stack of sample policies from the IASB, but I sat here and watched this board a long time picking through those sample policies and choosing some and disqualifying others as not representing this district. So why did you choose this particular policy when you did not rubber stamp all policies? Why this one? It can't be that it was recommended by the IASB when you did not choose all of the recommendations. In summary, I would recommend no change to the Elmhurst School District's current policy on public comment. It worked. Perhaps it offended some board members or administrators, but opposing viewpoints occasionally do.
Thank you. Our next speaker is John Morrissey.
Hi, my name is John Morrissey. I live at 460 Poplar. Early this morning, I sent to the board a letter outlining my concerns with the Section 2 of the policy. And basically, it's a continuation from what I spoke about earlier this year when the Elmhurst doings editorialized that there was some heavy-handedness with this board in terms of how they affect policy and define policy. And as you go through Section 2, I believe you find items in there not supported by the First Amendment of the United States Constitution nor the Illinois School Code 105 and the Illinois compiled statutes. The bottom line is that a board member cannot fully uphold his or her oath of office and can still be forced by the majority of this board out of office because they didn't follow this policy. And I think that's unfair because I think the board member has his first obligation to the United States Constitution and to the laws of Illinois, and then maybe to board policy. But an example of it, they said the first one on the code of conduct or ethics is that a board member can't be captured by a partisan political group. But we have one board member right now who's running for a partisan elective office. Many of the board members have taken positions on school funding, which is partisan. So I don't even know why that rule is there. And it's not in the national or the state school board association ethics. So they had the good wisdom not to use it. I don't know why we're doing it. The last thing, and I'll be quick about this, to talk about, and that is the communication from board member to board member. Now, I don't know who wrote this or why they wrote this. It is like little kids. It's like one board member can't talk to another board member unless this is the case. The school board, the legislature wrote the Open Meeting Act with the intent of allowing people to come to meetings. They did not write it with the intent of board members or officials in this state not to be able to talk to one another. And if one board member wants to talk to one individual on seven different individuals on 7 different occasions, that should not be in violation of their policy. And right now it is. And I would suggest that the attorney read the Open Meetings Act. They know, in fact, they have. They know what's going on here. They just want to, kind of keep this a nice little club where everybody comes up here and the 4 votes wins, and that's all you hear. And that's good. That's nice. That's the way people want to run business. And unfortunately, in a democracy, from time to time, it doesn't work that way. Thank you.
Thank you. Our next speaker is Laura Kratz.
I'm Laura Kratz. I live at 292 Forest, and I'm speaking tonight as the president of the League of Women Voters. I'm here to speak about provisions in policy number 2:230 dealing with public participation at board meetings. We are concerned that some new provisions in this policy step on the public's right to free speech and could result in expensive legal challenges. First of all, there's the guideline requiring that anyone appearing before the board must conduct oneself with respect and civility toward others. That sounds reasonable. However, the problem is that the terms respect and civility are not defined in the policy and are open to many interpretations. A person who's nervous about public speaking can come across as uncivil. At the same time, some people think that all criticism of the board is disrespectful. Another problem we have with the policy as it's written goes on to give the board president expansive powers over public speech. It says that the president may shorten or lengthen an individual's opportunity to speak, but that's based on what? At a given meeting, will everyone's speaking time be altered or just certain individuals? How is the public to know what the rules are and if they're being applied fairly? And the next power, the president can deny an individual the opportunity to speak if the individual has previously addressed the board on the same subject within the past 2 months. I don't understand why this is even in here. You already have a reasonable time limit for each speaker. Controlling content is a blatant infringement of individual rights. Then the policy goes on to let the president determine procedural matters regarding public participation not otherwise defined in board policy. How and when will this be done? This is so vague you cannot ensure that it will possibly be fair. Now, I sympathize. I know some of you have talked to me about how difficult it is And I've had to do it myself, to sit here and be publicly criticized, especially when you think the person doing it is full of beans. And it's also very aggravating to read their quotations in the newspapers. And I found this myself when I've not had the chance to defend myself. But that goes with the job, both yours and mine. Hearing questions and concerns of the community is board business. So I strongly encourage you to edit policy number 2:230 to preserve our right to free speech so that you can use our school district money to educate our children and not to defend bad policy in the courts. Thank you.
Thank you. Our last speaker is Terry Pastica.
Good evening. My name is Terry Pastica. I'm from the Citizen Advocacy Center, 182 North York Road. I like the lights. That's very helpful. I'm also here to talk about the public participation at Board of Education meetings 2:230 proposed policy. I want to let you know this has been an ongoing dialogue between the Citizen Advocacy Center and the board. Last summer, we received some phone calls from people who felt that the public comment practices at the school board were discriminatory. And so we had an opportunity to have a couple of communications with you, as well as have a meeting with the board president, another board member, the superintendent, and your attorney, talking about some of our issues. And it was I felt a very positive meeting. I think that we came to some resolution. Some issues that we were concerned about in terms of wording of issues on the website were taken down. And I think we really came down to two things. One is, my understanding is that the board members present felt a need to express civility and respect for the process was important to communicate to the public in public comment. And also, we talked about consistency in applying time limit applications, which is I'm so happy to see this light, although it's a little neurotic to see the countdown. Two things. Regarding the respect and civility, we heard a couple of public comments. I think what happened up at City Hall a couple of weeks ago is illustrative of why it's so difficult to define respect and civility. And I think that makes the issue in and of itself. There is no case law that talks about how do you define respect and civility in the Seventh Circuit. And I would hate to see this district be the test case in the Seventh Circuit. That's number one. Number two, in regards to the board president shortening and lengthening an individual's opportunity to speak, I think you have a conflict in the policy, because in one section it says if you need extra time to speak, you can get permission prior, but it's a rarity, or it implies unusual circumstance. And then later in the section it talks about that the board president can shorten or lengthen. I think that's a conflict, because it makes it seem as if it's a rarity to get to speak over 3 minutes, but then at the same time you say that the board president can shorten or lengthen based on his or her discretion. I think that's problematic, because the only way to shorten or lengthen someone's time to speak is based on what they say, or if you have a room full and you say, you know what, we have a big group tonight, we're going to cut everybody's time to 2 minutes and that's it. And the last thing that I think also is the prohibiting someone to speak, the opportunity to stop someone to speak if they repeat themselves in the 2-month period. I think that's also problematic unless you say across the board nobody can repeat themselves within a 2-month period, because otherwise I just don't understand how you can effectively implement that without basing it on what someone intends to say. If the intent is to move the meeting along, I think you need to limit public comment overall to 30 minutes and stick to the 3-minute rule.
Okay.
Thank you.
Thank you. To all of our speakers, we appreciate you coming and addressing the board. For those that are not familiar with our public comment practices, we don't address the public comments. We have an agenda within which our discussion at the table is centered. However, some of these issues may be discussed tonight because these policies are the very topics we'll be addressing. So again, thank you, and we are going to move forward to our only superintendent's communication item tonight, which is the draft Board of Education revised, updated, and policy manual.
And I think I'm going to defer this to you, Mrs. Ostojic, so that policy chair. I'm going to defer this to you, Mrs. Ostojic, so that to give an overview of what this process has looked like could be shared by Maria Hirsch.
And with that, I'm going to ask our policy chair just to give some background information, and then we'll talk about what process we'll be engaging in this evening.
Okay, thank you very much. I just want to give some background for those of you that weren't closely watching what the board has been doing for the last 2 years. But the Board of Education governs using written policies. These policies ensure legal compliance. They establish board processes, articulate district goals, delegate authority, and define operating limits. The current policy manual, which is this blue manual that we've all been operating out of, was authored by board members based on IASB recommended policies at that time. It was adopted in 1999, and those core policies are still in effect. In fact, those are the policies that govern how we operate today. The district has in the past and continues in the present to contract with the Illinois Association of School Boards, or IASB, to provide notification and recommendations when a policy needs to be updated based on changes in legislation. Individual policies have been updated and adopted over the years to remain compliant with changes in legislation and changing goals of the district. As part of the strategic planning process undertaken in 2008, the board determined the structure and organization of the current policy manual made it difficult for administrators to locate policies and difficult for the Board of Education to keep the policy manual compliant with changing legislation. In September of 2008, the board voted to use the services of the IASB Policy Services Team to adopt their current recommended policy manual structure and adapt the IASB recommended policies as is possible within the law to reflect the values and beliefs of the greater Elmhurst community. The proposed manual consists of 8 sections. Section 1 addresses school district organization. Section 2 addresses the Board of Education. Section 3, general school administration. Section 4, operational services. Section 5 addresses personnel. Section 6 is instruction of students. Section 7 is students themselves. Section 8 is community relations. By adopting this new structure and staying close to the recommended policy wording, the Board of Education can leverage the work of the IASB Policy Services Team and their attorneys, ensuring timely compliance with new state and federal legislation and engaging in best practices in school governance. The district continues to receive quarterly updates with recommended and required policy changes, which can now more easily be compared and integrated into our district policies. The board has been meeting as a committee of the whole since that time that the board at the time decided to make changes to the manual. And we have been reviewing and revising the policies as they were presented to the board by the IASB. Since I joined the board in April of 2009 and I assumed the chair of the policy committee, this board has met as a committee of the whole 17 times to discuss and agree upon changes to the IASB recommended policies. Those changes have been integrated into the proposed policy manual that was provided to board members on July 20th and posted on our website on August 4th for the public to review. Now, the process for adoption, or the board adhering to and agreeing upon this new policy manual moving forward, we live under our current policy manual, which this is defined by our current policy 1400, policy development. It indicates that adoption of new policies or changes to or elimination of policies shall require a 2/3 vote of all members of the board, which is 5 out of 7 members, and shall be considered at 2 separate business meetings of the board as a first and then a second reading. Tonight, the board is holding the first reading of the proposed new policy manual. Changes can and most likely will be made to individual policies based on community feedback and continued ongoing board discussion. Any changes agreed upon by the Board of Education will be incorporated into the proposed policy manual and reposted for the second reading, which we are expecting to occur this fall. At this time, I'd like to ask the board president if we can proceed to the first reading.
I'm going to ask a procedural question because we started this under superintendent's communication. However, now we're moving to the consent agenda. So I guess that the way we're proceeding is should we take the whole policy as a whole, or do you want to move as a consent agenda as laid out through each section of it?
Dr. Krizik and I had some discussions around this earlier today, and looking at what the first policy reading, what really this is indicating is that the Board of Education is moving ahead in the process of adopting changes to our policies, whether that be a change, a deletion, an addition. And so we are starting officially on the process. And what that means is we actually posted our proposed policies early in August because we wanted to give the general public an opportunity to review them. But this is the official meeting where we are actually requesting that we post the policies, we make them available, and we invite public comment. So the board is not, by approving to move to first reading, the board members tonight are not necessarily agreeing to any specific wording that is any of the current policies. It is beginning the process of approving the policies for first reading. I would recommend, but I would entertain board discussion that we just go ahead as take the policy manual as its whole, post it for first reading. It will be difficult for us, and I think a burden on the administration, if the board were to move forward adopting the policy manual piecemeal. In other words, sections 1, 2, and 3, because our current policy manual as it exists today, which is what rules how the board operates and how the district is run, is in 5 chapters that are not necessarily mapped to the proposed policy manual. So it's going to be a challenge to try to move forward adopting a portion of the policy manual as opposed to it in its entirety. But the decision tonight is to decide to go ahead with the process.
So I guess I'd like a motion for the board to adopt the first reading of the policy manual, and following that we can have discussion on those items we want to have discussion on. Can I have a motion? Mr. Collins?
I move the Board of Education adopt the first reading of our proposed policy manual.
Is there a second? Second by Ms. Hirsch. Okay, now we'll move on to board discussion. Mr. Carlquist.
I'd just like a clarification. Ms. Hirsch, you went through the existing policy which governs, and in what you read, it said that we take action on policy adoption readings at business meetings. This is a special meeting of the Board of Education. It is not formally one of our business meetings. So I think we need to have at least some consideration as to whether or not it's even appropriate to take action at this evening's meeting formally for first reading. Beyond that, I think we can have some discussion in terms of the substance. I would caution us not to move. I think all of us are interested in having this buttoned up. We've been working on this for several years. You talked about 17 meetings we've had just since you've stepped into the chair role. But there are still this is really the first time as a committee of the whole we're having any discussion over the compilation of this draft. I know I had a variety of things ranging from typographical errors to substantive issues, and my expectation or hope was that we were going to continue in the discussion of trying to reflect public input, trying to capture 7 board members' points of view on what should be changed. So I would just caution us not to be too hasty in terms of trying to get to job end, that we short-circuit the process, and most of all, I want to make sure that we aren't in conflict with what the existing board policy says.
Mr. Carlquist, I fully anticipate that any board member can enter into discussions on any of the policies. Each one of these policies has been reviewed by a quorum of the board over the last 2 years. So this is definitely not the first time that any of us have seen. It might be the first time that you've looked at it as a compilation, but with the exception of cross-references from one policy to another, which I believe we tried really hard to make sure that we got all the cross-references correct. There really is not a lot of dependency across policies. So the discussions that we have had, we're open. If we've got typos that I missed, that Mrs. Walsh missed, we'd love to hear them. I think we do have an opportunity to have substantive discussion around policy at this point. That's the purpose of the meeting. In terms of the special meeting versus the business meeting, I apologize. That was probably my oversight in working with the superintendent. Our intention was to schedule a meeting where we did not have other board business on the agenda so that we could dedicate the necessary time to have a full discussion. So if we posted the meeting improperly, I apologize. That probably was my oversight. But the intention was to make it widely known and publicly that this was a policy meeting to discuss all of the policies that are being teed up as first reading.
Ms. Hirsch, I know that we've received in advance a laundry list of items that the Board of Education members wanted to bring back and have additional conversation or evaluation on. In addition, I guess if there's something else that comes up at the table this evening, we can approach that. How would you like to proceed with evaluation of those items?
The request was to provide in advance, if we could, the specific policies and the specific concerns that we have. Given that we've all looked at all these policies several times over, maybe if it's the willingness of the board, we can go section by section, and if an individual board member has a specific concern about a policy, that you raise that particular policy as we hit that section, and we'll have a quick discussion around it. And see if we can come to resolution and resolve those policies, if that's acceptable to the board.
Mrs. Davy.
I'd like to speak to the motion that's on the floor. I think as I looked at the draft, I felt very good about the work that we collectively have done, because it has been over a period of time. It's been very thoughtful. We're not finished. When I went through, I identified 35 policies of my own that I still have clarification or questions about, and there are a couple that we had put aside that we wanted to put aside to have a full board further discussion, philosophical policy issues. And I know you shouldn't put I understand you don't put philosophy in policy, but some of the things that we value that come out of our strategic plan, how are they reflective in our policy manual? We put those aside, and we have not come back to them collectively as a group. And for that reason, I'm voting against this motion, because I don't think we're ready to go to first reading. I think we're doing great work. I think this meeting will have great value tonight. We can begin the process of going through one by one. There's nothing stopping us from doing that, whether we're at first reading or not. I think it becomes a label, and I think it's a dangerous first label to say that we've gone to first reading before we're ready to. And I as one board member, don't think we're ready for a first reading.
Okay, thank you, Mrs. Davy. And I think the intent here is that if there are substantial, after we go through these sections, if there are substantial issues that we've not resolved, we'll agree to a process of how those will be resolved. If they're significant, obviously the first reading is very premature. If there's only a few issues left and a couple of things that we can address before our second reading, you may change your vote. So with that, Ms. Hirsch, do you want to go ahead and start moving through the sections?
Section 1. I ask that board members that have specific questions about a particular policy in the first section, go ahead and indicate that you'd like to bring up a new issue. Mrs. Osternick?
I guess I would just like to make a comment. We did receive some community input specifically relating to item 1:30, and it focused on, if we should be changing the content of this to be more focused on resource conservation and so forth. And I guess the comment I wanted to make on this is this document reflects the vision, mission, and belief statements of our district as they exist today. And those were developed as part of our strategic planning process. So could they be updated? Yes, they could be updated, but this policy reflects what they are as they exist today, and that is essentially why they're laid out in the way that they are. So just to, I guess, address a comment or concern that was raised on that policy. That's all I have on that section. Mrs. Deroni?
I really like that suggestion by that community member, that we have such a policy. I don't know that it goes right here. It may go farther back in the book under operations, or I don't know where it goes. Maybe there should be a sentence here as well as one back there, but I am persuaded that we missed the boat on this one. We need a sustainability policy of some sort, a green policy. And I would suggest that we either send that back to the policy committee before we go to first reading and get one of those. I don't know if there's any out there I don't remember seeing one in the IASB pack, but that doesn't mean we can't have one, make it up ourselves, whatever, but do some research and include that in our new policy manual. I think we would be remiss if we did not.
Ms. Hirsch?
Actually, that was a policy that was originally proposed in the policy manual. There was a policy that addressed that specifically, and the board, through its review, decided to eliminate that policy. So in a previous meeting, we had IASB proposed a policy that addressed that very issue, and it was something that the quorum of the board sitting at the meeting at the time made the determination that we would delete that policy. So I believe actually Mrs. Davy and the policies that she indicated that she would like to review, it's later on in the manual, but that is something that we can look to reintroduce and see if we can include that policy back into the manual. That could be something that can be brought back.
Mr. Kralkowitz?
As I recall, again, we're going back over the last 2.5 years in the process, but as I recall, that proposed language from the IASB did come up in a later chapter after we had discussed Section 1. And if I also recall, this whole policy 1-30 was really our customization of a category that the IASB had, but really this was very personalized, and in fact, even down to, I believe, the heading, where we thought that this would be a unique place where we could capture the philosophy and values of the district that ultimately might guide policy. I think it would be appropriate to have deliberation over a sustainability policy, and could be something we would refer to the policy committee to have be supplemental to this policy guide. Doesn't necessarily have to be adopted at this point, but I do think that 1:30 is a place that we could easily enough, simply enough, insert a statement, a sentence, a belief statement, much like we have around things like climate, as in the district climate, and citizenship and diversity and the like, around a philosophical perspective that's shared by this board on sustainability and green and conservation and so forth. So without perhaps a lot of difficulty, whether we constructed our, in preparation for the next meeting, this would be an easy place to insert, and then ask the policy committee in its ongoing work to reevaluate best practices and other policy language, not just from the ISB, but other districts, other communities. Was there, Mrs. Osijek, in the input that you had received, was there any suggested language that would be inserted here, or was it just more of a categorical input?
Excuse me, it was more categorical, but it was, we received actually 2 comments relating to that, and they were more than just belief statements, looking for specifics to be woven throughout our policy manual. But I think I would agree with you. I think a value statement here would be something that this board could definitely discuss and add to this page. Mr. Collins?
So are you suggesting that we try to write that statement right now, or refer it to the policy committee and bring it back for further discussion? The other thing I'd like to ask, well, first of all, I think the more eyes we have on this policy manual, meaning the community's input, the better the end result will be. So I encourage any community member that can take the time and read it to comment on it, please. But back to this particular statement, I agree. I think we should have a statement in here. I'd like to go back and review that original statement that the IASB recommended and compare it and build off of it, in addition to incorporating the suggestions that those two community members had. So what's your suggestion on how do we proceed? Do we refer it back to policy and come back?
I would say at this point, we're going to keep a list and we'll refer it back to policy. Mrs. Davy, did you have a comment on this section?
Okay. Seeing no further comments on Section 1, let's go ahead and move on to Section 2, School Board. Mr. Kralkus?
Perhaps you could explain in policy 2:80. Again, as I recall in our discussion, there was a policy statement from the IASB. There was an exhibit, and that's a whole other subject that I think we need to discuss, which is the appropriateness or inappropriateness of exhibits being peppered throughout this manual. There's a lot of exhibits that were inserted that weren't a part of the original meetings that we've been having over the last couple of years, so I think we need to discuss what the role is of those exhibits. But as I remember, we talked about, the IASB had sort of their code that they were advocating, but that we said that there was also National School Board Association language, and it looks like in this document, both documents were just inserted, and at best case they're redundant. In some cases they aren't perfectly aligned. Can you explain or just describe your expectations on the role of these exhibits, or how this language relates to supports the policy language then that's in 2:80?
In general, I would like to first address the exhibits that are included throughout the policy manual. The role of the IASB is to create sample policies, and then the next step beyond the policies, once the policies have been adopted, it is up to the administration, in general terms, to create procedures which align with and support the policies that the board dictates. So in some of the chapters later on, when you look at general school administration, operational services, personnel, there were some exhibits that this board has not and would not actually review, other than maybe for understanding what the implementation is going to look like. It would be up to the administration to develop procedures for each of the policies that the board adopts. There are recommended procedures from the IASB as well. It's a little unusual, Mr. Carlquist, in this particular section, because this section addresses the Board of Education. It does not address the running of the schools and personnel issues and student issues. So in this particular section, again, IASB is making recommended procedures for the Board of Education and how the Board of Education is going to conduct itself. On this, which is something that we've discussed as a board, we've discussed several times in terms of the idea, once we can firm up and agree upon the policy manual, that it's something that the board could consider in the future to develop a procedures manual which would guide board operations. However, in this particular case, I remember, Mrs. Davy, that you had come back with Mrs. Conroy, having been to the National School Board Conference at the time that we had discussed this. I know that you were very excited about the veracity and the way that the Code of Conduct was written. The National School Board Code of Conduct was, in your opinion, if I don't want to speak for you, but my recollection is that you felt that it was a much stronger Code of Conduct and it would be preferred. And I think we came to the conclusion at that meeting that we would include both the Illinois Association of School Boards recommended Code of Conduct as well as the National School Board's recommended Code of Conduct. I don't think that we looked at them carefully enough at the time to discern if there were conflicts within those. It's something that we can definitely take a look at now if you've identified conflicts between those two code of conduct policies. But that in this particular instance of this one particular policy, we actually reference the Illinois Association of School Boards Code of Conduct and the NSBA's Code of Conduct in the policy, and we indicate that it would be displayed in the boardroom, and they are included in the policy manual, I believe, to that effect.
And if I recall, the reason why we did include them in here, because these are procedures for board members which wouldn't be in the manual that the administration and staff of the district would be using. There was no other place really to keep these. So I guess it's up to this board whether or not we want to retain these here. But that was the intent for putting them here in the first place. Mrs. Conroy.
In terms of these exhibits, I've been kind of directly referenced this evening in 1 and 2, and I would say that because I take my school board role incredibly seriously, I have not had an issue with 1 and 2. Do I see that it could be an issue for a school board member? I think it could be an issue. So I think I'd like to open up a discussion about how my fellow board members feel about the type of position they could potentially, or other board members going forward, could be put in.
Items 1 and 2 were 2 items that were addressed through concerns addressed through community input. So the first, and as Mrs. Conroy said in public comment tonight, the responsibilities to not lose a representation of our constituency through distractions of special interest, political partisan groups. We did, I mean, this is consistent with the IASB, right? This is not one of the documents that we edited. And do you recall, Ms. Hirsch, was this one of the ones that we could edit? This is optional to put in here, but if we put it in there, it had to be verbatim this way. Is that correct?
Correct. We can't make modifications to the IASB recommended board member code of conduct. In fact, I checked it on the website this afternoon as I was doing my research. So it is as represented in our book. It is represented on their website. I think the only thing that I'll say to Mrs. Conroy's concerns is my understanding and my reading, and I would say that we would probably want to get some, some outside opinions. But the way that I read this particular code of conduct, it's indicating that an individual board member will represent the school district constituents honestly and equally and refuse to surrender my responsibilities to a special interest or partisan politic groups, specifically the first point. And while we all take our board work very seriously, we also have other lives and other responsibilities that revolve around that. And I'm assuming that we all have adhered to this code of conduct as far as I'm concerned, and it is to my knowledge. And when we come to the board table, we are representing the best interests of the district at the table, and we may have other opportunities that are going on the other parts of our multifaceted lives. But in terms of this, I don't know that this would be a problem for Mrs. Conroy.
So getting back to these exhibits, we either have the option of including them as they are written by these 2 organizations, which we've referenced, or omitting them. We have included them again because they aren't available to most people who would see this reference any other place. So I guess I would look for input from the board on your opinion on whether we could resolve this. First, whether we should be including these exhibits in here or not. Mr. Kralquist.
So I just, for some clarification, like to maybe double click on this one, Mrs. Conroy, since you brought this up. I mean, this has been something that the ISB has long advocated. And so as you point out, Mrs. Ostick, there's sort of 2 parts to this discussion. One is, do we continue with what the policy committee was suggesting with the language, which is include the code of conduct as an extension of the policy as an exhibit? And then secondarily is if we do, what's the interpretation of items 1 and 2? I mean, it says, one will not surrender their responsibilities as a school board member to special interest. That could be athletic boosters, the drama club, or some other entity, or partisan political groups. I'm curious, since you are running for a partisan political office, how would you interpret that? Does that mean that your school board interests, school district interests, would supersede any and supersede any partisan interests or position, or would you see those as distinct? What?
The
it's an
reason,
interesting test case.
right? The reason I brought it up, because it does apply to me, is I have never had any issue with conflict. I don't. That is, like Mrs. Hirsch said, that's another part of my life. It has nothing to do with what goes on at this table. I've not seen it that way. I've not had any moment of feeling compromised by what I'm doing outside of this table. I've been able to put the best interest of the district first and don't see a conflict. I haven't personally. I don't know if that means someone else might, but I have not personally, no.
And then the other piece, again, these are small items, but in our policy committee meetings, these are words have been what we've been laboring over in many cases. The policy says the board adopts, which is a pretty strong verb, versus the codes talk about I will do my utmost or I will strive. And again, while not necessarily an overt contradiction, I think it's a subtlety that we need to think about, particularly as it protects either individual board members or protects the public if there are to be, or the district, if there are to be claims or accusations of perception of conflict of interest, whether or not a real conflict exists.
Mrs. Kep.
I think on the same lines that Mr. Carlquist was just speaking about, I think the area of concern is the gray area and the interpretation of how somebody interprets this, and not, regardless of my position, I think it's looking forwards and looking at other potential issues and never having to go and spend district money on defending something that basically is a gray area.
If I remember correctly, I mean, the reason why we put these two in here was we felt very strongly that we wanted to make a statement about our understanding of what interests we were representing here. And we did not see at that time these in conflicting. And again, I haven't looked at these in probably 6 months, but it's still my belief that these do represent what the responsibilities of us as individuals, because this is, an individual statement that we should be making collectively and individually. So my vote would be to still keep them in here. Mrs. Davey.
I will be the first to admit that I brought back with Mrs. Conroy the NASB one because we had been to the national convention and it was fresh on our minds, and I think it's called a code of ethics rather than oath and conduct, just for a little clarification. But I will say that I think it's dangerous to put too many exhibits in a policy manual. I do understand why there's no other place, procedure manual to put these. I do understand that rationale. But the more I've listened to this discussion, and then the more I look at Policy 280 in and of itself and what our oath is, I feel like that our oath of office is what covers the overarching responsibilities and commitments we are making. And so I could see where we don't really have to have the other two exhibits. They're add-ons, and they put some body around our oath, but the oath is really, it's really the brass tacks. When we have been elected and raise our hand to agree to solemnly swear, I think the oath really is covering it, and we may get ourselves in trouble by trying to add more things than what the actual oath is.
So I guess I would look for a consensus from the board to just stick with the core oath on here and remove we have two options: either stick with the oath and remove the reference to the additional things, or refer this back to the policy committee for additional discussion. Mr. Carlquist.
Yeah, I agree with what Mrs. Davy is saying. I think on one hand, the code of conduct and the code of ethics from the NSBA are very good and are the way board members should conduct themselves. And so on one hand, and I think that's why the suggestion was made by you and Mrs. Conroy at that policy meeting to include these, because it is the way a board member should conduct oneself, and you would come back and you even supplement it with the ISB, brought forward. But at the same time, if we include it and we use words like adopt, I think it puts someone like Ms. Conroy in a jackpot, in a very difficult situation, because it is very difficult to defend where is the line cross with partisan politics. And I just use that as the example because that was brought up as one, but there are others that could be used as evidence as well. So perhaps the most straightforward way is to omit the last piece. And as I recall somewhere in here that we had policy language that talked about training or development or onboarding, inculcating new board members, and perhaps the code of conduct and the ethics is something that could or should be an element of that. But to put it in here as policy adoption, I think could be problematic.
Mrs. Deroni.
I also agree that exhibits have no place in our policy manual. I understand and I remember why we wanted to add these here, but when I look at the whole manual now as one piece, I don't see that anything that's labeled exhibit fits. If we want to take this and make 2:81 and call it what's the first one is the board member oath, and then we could have board member ethics or something, take that back to the policy committee and rework those and do that. Or, as you suggest, Mr. Carlquist, and I think you, Mrs. Hirsch, had originally suggested that we have some sort of handbook for the board similar to the one that the superintendent would develop from this policy manual as a procedures, administrative procedures. We could have board procedures. This type of, these two exhibits might go into a piece like that, but again, we kind of just threw them in because, hey, these are supported behaviors by the two groups that we belong to. Let's have them, and then we moved on. So we should probably, if we really want to make it our own, combine these two, take the best of both, and put them in a board handbook, or have a whole separate policy on board member ethics.
Ms. Hirsch.
I can pull up, we subscribe to press, the IASB press online, so I just pulled it up, and Mr. Carlquist, the recommended wording that's coming, again, this is the starting point, the recommended wording is the board adopts the Illinois Association of School Boards Code of Conduct for members of school boards. We added the National School Board. So, in terms of the adoption and the strength of that, that's what's coming to us from IASB. I don't have a problem, my opinion at this point, I believe in the board member code of conduct. We can have a discussion as to which one this board would like to adhere to. I don't know that I agree it doesn't have to be in the policy manual. However, I do think it is important that this information is public and known, and that the board lives up to these standards. I think that's an important piece to communicate to the community.
Mr. Collins.
I wasn't on the board when this was initially discussed, but I certainly have whether you label these as exhibits or as separate section numbers, I, first of all, have no objection to them being on there, because I don't see, I see benefit in wrapping this in some specificity, if I pronounce that correctly, as to what is expected of the conduct of a board member. And plus, by having them readily accessible in the policy manual, I just think that it's good community service to make it easy for a community member to find that code rather than have to hunt for it in a separate document.
Okay, I guess I'm going to make a recommendation because what we want to try to do tonight is get through as much as we can. That obviously this isn't a simple one. We're going to have to set this aside and do some additional work on. So we've got 2:80. So if there are any other, we'll move on through section 2. We've got that one tagged as and including the attachments E1 and E2 to be addressed as follow-up. Any other, Mrs. Davy?
I had notes on policy 240 that we were going to add a cross-reference to nepotism, and that cross-reference is 2106. And I didn't see that. Did anyone else have those notes? Then that was the nepotism we'll be coming to, but that was something new. Okay, and then I had notes on 230, 2:30 and 2:50 that they were both on hold, and I just wondered if if there was a resolution to why both of those were on hold.
I will answer that. I don't have any recollection or notes in my original book that I was taking notes in as we were going through this as to why this was on hold. On 2:30, we did remove a sentence that addressed the canvassing of the votes is conducted by the election authority within 21 days after the election. That is a statement of fact that has nothing to do with our policy. And so we removed that sentence out of 2:30. 2:40, I did not have notes. Thanks for the catch on the cross-reference on the nepotism. And on 250, I did not have any notes on 250. And when I say I didn't have any notes, I'm referring to the book that I've been using throughout the process for discussion. And I also, just for board members' information as well, I used my notes to go back and check against the policy manual that you're looking at that was dated July 20th. I also sat down with Mrs. Ellen Walsh, who is the superintendent's assistant, who was taking notes at all of our board policy meetings. And between her copy and Dr. Krizik's copy and my copy, we merged and tried to make sure that we captured any changes, notes, recommendations that were discussed in meetings. So I apologize. We might have missed a couple. Mrs. Walsh?
Yeah, it's the same one. I thought there was something that we went for going. I thought that it was on hold for some clarification issue, and I guess I was just looking to make sure that the clarification was made.
Are there any other policies in Section 2?
Mrs. Conroy?
Yes, as has been discussed by community members and concern of mine as well is 2:230. When we're speaking about the First Amendment, I think we need to have an open discussion about that.
Okay, I guess in follow-up on that, your specific concerns on this policy?
Specifically, I have concern that this policy does go against First Amendment rights. I don't think we have the right. There's so much gray involved in this, and I think that when we try to define gray, we're setting ourselves up for potential lawsuits. And I think that as a president or anyone in a leadership role trying to define gray for the community is asking for trouble. I think that when there are so many issues that we have dealt with in the last 2 years that have so many different pieces to them, that by saying to someone you can't bring it up more than once within a 2-month period, I think that's definitely attacking someone's right to free speech. I think that that's wrong. I think that that we need to be very cognizant of that, and I'd like to hear what the rest of my board members think about that.
So your specific concern on this is the reference to the president, the sentence may deny an individual the opportunity if the individual has previously addressed the board.
That, as well as the way that you define someone who would be not respectful. I think that's difficult as well to define.
Ms. Hirsch.
I'd just like to give a little background on the policy that's in front of you. We did have discussions last summer with the Citizens Advocacy Center and did have great meeting and trying to work through this. And this policy as proposed is different than the policy that we are currently living with. And the policy that is proposed, what happened is we had discussions and put this on hold as a board because we wanted to get our attorney's recommendation on the proposed policies. We selected a few policies, asked our attorneys to review them, and our attorneys got back to us with the recommended changes. So this policy, as you're looking at it now, started with the IASB recommended policy and reflects changes that our board attorneys have recommended to give us advice and counsel as a board. I don't believe that as a board we've actually discussed in detail this particular policy, but I just wanted to give you some, that's what this policy as it reads now is. It has been reviewed by our attorneys and was brought back to the board.
Mrs. Conroy.
I understand that we've gone to our attorneys and the question that we've asked them is, are we compliant with the law? My specific question for our attorneys would be, if this were to be tested in a court of law, would we win?
This policy is cross-referenced to 8:30, which defines, I think, for purposes of us as an organization, what mutual respect, civility, and orderly conduct looks like. And so I know that it's referenced clearly in the policy, but I'm looking at those 10, 14 items, and with the, I guess, exception of number 14, which we leave up to administrators to decide when they're supervising school activities. I'm just saying there is a cross-reference to 8:30. So I just wanted to kind of point that out. So it's a little less gray, so to speak, because the expectations that this is referring to here would be the same that we would expect in our schools. So I just wanted to point that out. I'm not just pointing that out.
Mrs. Conroy.
So I think, again, I would like the answer to that question. The question is, if we pose this question to our attorneys and this were to be tested, would his advice be to us that, yes, we would win this case, or he can't guarantee that?
Okay, here's my recommendation on this one. We've received a lot of input on this tonight. This isn't something that the board has had discussion on in this context, that I would ask that this one also be put on our list of things that need to be, just in the interest of getting through what we can get through tonight. I'm going to throw an additional one out, and I know this was something that we had a lot of conversation about in the past, and there was the request to revisit 2:110. And the specific concerns that we, conversation was whether, we should be specifying a 2-year term in here, or, you could be elected up to 3 consecutive 1-year terms. We had a lot of conversation. I think when we moved forward on this one, we were still at a point where we weren't all 100%. So I wanted to bring this one back. Mr. Carlquist.
Yes, this is one that I had annotated that I wanted to bring up again, and I know we've had some discussion, different points of view. I for one, am not supportive of this policy in the way that it's written right now, and couldn't support it. They're really, without going into a lot of detail and regurgitating some of the supporting evidence that I gave in our policy committee meeting, the 3 main points are, generally speaking, number one is I'm not in favor of term limits. I think the will of the board should speak for its leadership. In this case, one could argue that the term limit is somewhat moot in that it's 3 terms of 2 years or 6 years, and in the past, probably in the history of this district, there's never been someone that has served anywhere close to that amount of time. But regardless, I think a term limit is not a good practice. Secondly, I don't support the minimum requirement of a 2-year term. Again, I think the will of the board should speak, especially for its leadership. When I think about the role of the president, things can rise, or things can come up that perhaps the right skills, the right leadership at the right time could be appropriate for a term that's less than 12 months or less than 2 years, such as 1 year, which is what the existing policy calls for. And then thirdly, I think the requirement that the vice president permanently fills the role of president, I think again is a diversion from past practice and current policy. That one I'm not as hung up about, but I do think it again, the role of a president and a school board is sufficiently unique. It's not like other governing bodies. There are no special powers or authorities other than the fact that the individual is the spokesperson for the board and provides the leadership with the support or backing of the majority of the board. And I can conceive of all sorts of situations where there logically would be an officer who has been or an individual member of the board to serve as vice president with the support of the full board for that particular role, but not necessarily to accede permanently. Certainly in an interim or in a transitional basis. So those are three things that I think are not only significant diversions from past practice. I don't see them as essential elements to the policy. In other words, what real problem are we trying to solve by making those changes?
Any other board discussion on this item? Mrs. Deroni.
I've got a couple of issues with this one. The first line says that the Board of Education officers are president, vice president, secretary, and treasurer. These officers are elected at the board's organizational meeting. Well, we don't elect a treasurer. So that's wrong. Something we all missed first time around. I also think that I thought board elects officers from its members for a 2-year term. I'm kind of rethinking that as well. The term limits, or rather, that no officer shall serve for more than, I think, 2 consecutive terms is plenty. I don't know. As I read it again, it just seemed like whatever it was that the majority of the board came to consensus on wasn't holding true for me when I read it again this time. The vacancy of the presidency, I think, should be filled by the vice president until such time as a new president is elected. I just think that's, for the reasons that Mr. Carlquist just stated, is something that we should have in here. And it should be by special board election, just as the vacancy in the vice president is filled by special board election. And we have nothing that says that, I think the old policy said a vice president shall serve as secretary in the event of the absence of secretary or the inability of the secretary to perform duties. And then just a housekeeping piece down at the bottom here under secretary, duties of the secretary. Instead of mail the meeting notifications, it should be provide, because to news media agencies, we don't mail them anymore. Duties of the secretary, number 2. It says mail meeting notification and agenda to news media who have officially requested copies. That's just, I think that word should be changed to provide. Under the recording secretary place on the next page, we're kind of silent on who takes minutes in our closed sessions. And it might be helpful for us to have that. And the treasurer should be a member of the board or a non-member who serves at the board's pleasure. I mean, we've never had a member of the board serve as treasurer, do we? I don't know why that's in there. Those are my comments on this one.
Ms. Hirsch.
To give a little background on the idea of board members, board officers serving for a 2-year term, that we had a great discussion, actually. There were, I believe, 5 of us present that had lengthy discussions in terms of the amount of time that it takes to get up to speed to serve as a board member, and then the amount of time that it takes to get up to speed in terms of the procedures and running board meetings and serving in the role of board president. And I believe that there was expression of concern that having a 1-year presidency, it was challenging to get up to speed in the role of board president. So much of the discussion around board members serving as officers for a 2-year term really stemmed from the challenge of learning the role and leveraging the time that was invested to give that board member an opportunity to learn the job, to excel at the job, and then have some stability moving forward. So just to give you some insight in terms of board practice has been, in the old policy it says 1-year terms, but we really had a good discussion, I think, around the challenge of, especially with the board presidency, learning the job, understanding the role, being effective in that job, and I think there was some good discussion that we had around that. I would prefer to see us not change from a 2-year back to a 1-year. The term limits I don't have strong opinions on. And Mrs. Droney, I did have a couple of things. This policy that you're looking at, the policy committee had looked at an IASB recommended version of this policy, and we adopted those changes. And so when you look at things like, in terms of closed minutes, it's the duties of the secretary are to keep meeting minutes for all board meetings. That's inclusive of closed meetings. So there were a number of things that were streamlined in the most recent version of the IASB version of this policy. So those were things that I think we did review at the policy committee, this particular policy.
Mrs. Droney.
Thank you. You bring up excellent points, and you've jogged my memory on some of this. I would throw out to the board to consider that we ask that the president serve as a first term 2 years and 1 term after that, rather than 2 years, 2 years, 2 years.
Yeah, I'll tell you, 2 years, 2 years, 2 years.
Yeah.
Could be a really long time.
Kind of scary, isn't it?
Dog years, but.
I mean, I agree. It takes time to get up to speed. It does. You get a rhythm. You get to know the superintendent. You get better at the job after the first year. But so 2 years is a good thing for a board. But after that, if the president has other things to do with his or her life, I would say we should have a 2-year first term, and then 1 year after that. And the vice president and secretary, I think, should just travel around at 1 year. They're just sort of leadership roles. They give the person a little visibility. They sign documents. They sit in for the president. But to have that as a 2-year term, I don't see as a particular necessity.
I think what I struggled with this one is what should be policy versus what would be good practices. And, I think, Mr. Kralquist, what you're saying is, a board would be really silly to be changing out the roles every year. And, I'll tell you from my experience from board president, it does take a while to get the hang of things and really, as much as you're sitting here at the table when you're not running it, it's a little different seat to sit in. So, I struggled with this one. I felt pretty strongly. You make a big investment. You go through a lot of training to be president. But whether or not that should be board policy, that it has to be that way, I guess that I've sort of softened the way I've looked at that, just from a perspective of a lot of things could change. And it is a good practice, I think, to allow someone to develop for a few years so that they can, start to accomplish some goals and that kind of stuff. But if somebody's, looking to step out of the commitment, if the role isn't fitting right, do you lock yourself in that way from policy? And I guess from that perspective, one of the reasons why I brought this back is I've thought about this a lot. We had a lot of conversation about this. Probably my another year of experience has put it up in my mind a little bit more too. But I do think that there should be, and this is where I'm going to disagree with Mr. Kralquist. I think there should be some limit. You can go back and be president again, but there should be a transition role for, our current policy has three consecutive terms. The new one is also about consecutive terms. It doesn't say that you can't go back and play that role again later, but I do think having different voices at the table is important, and I would support. So I guess we're a little bit in conflict. I'm going the other way on whether it should be 2 years, but I guess I feel pretty strongly that there should be some point where there's a transition, and I think that is good policy. Mr. Cowell.
Two things. First of all, on the first point, I not because I think you tended to agree with what I was saying, but because I think you expressed it so well in terms of, I think every board member would agree it's good practice to have some history, some time under your feet as a president, as a leader in a role to really become effective, as you said, accomplish some goals. But I think I would leave that, just as you said, to practice. Let board members, come to that conclusion and take that kind of action rather than somehow decreeing it, protecting it, and mandating it. That's on the first part. On the second part, in terms of the term limits, while I might disagree, with the concept of term limits, what's in the policy, as I said, it's somewhat moot, is 6 years of term, because I philosophically agree with, I think, the point that you're espousing, which is leadership on a board of education should change because the role of the president does not have special tie-breaking powers, any special authority that transcends the other members of the board of education. Leadership is something that should be shared to anyone on the board who have the ability, has the support of the board, who have the interest and aspiration. And so, from that standpoint, I'd almost argue that if there is to be a term limit, it would be something less than 6 years, which is so outside of the range. So again, that one's probably not such a significant one. We could probably compromise to say either if there is to be a term limit, make it a smaller amount of time so that it really drives the sharing and the transition of leadership. But the way it reads right now, it just seems as if it was a notion that's not solving any problem. It's not. That's never been approached as a constraint here in the district, and just seems like superfluous language in the policy.
I guess what I would ask here, again, trying to move forward, is if we think we can reconcile this quickly, I would say let's try to do that. If we can't, I would put this on the list of things to come back to. Mr. Collins.
Having, again, thought about this since our initial discussion, I think Mrs. Duroni makes a good point and a good compromise of having that initial president's term being 2 years, followed by year consecutive terms. It also seems to me that the other positions can be a year at a time without any detrimental effect to the board. And then maybe we just put in a clause that says board presidents are encouraged to transition leadership after, pick a number, 4 years, 3 years, 5 years, whatever it may be. And if there's a special circumstance where the board feels that that president, for whatever circumstance, really needs to be president for a year beyond what that suggested is, it gives the board that flexibility. But it also puts in writing a suggestion, a strong suggestion, that the president turn over leadership after a specified number of years.
I'm going to suggest that we put this one aside, because I think we could debate the positives and negatives of each of the options here. If you're in year 3 of your term, do you not want to go for president because that would be your first time? And for example, that second year might cross you over an election period, and that's so. What I would suggest is that we put this one on the parking lot and keep moving forward. Ms. Hirsch.
Our parking lot is growing quickly. I would just like to see if there are any other areas of concern in this particular policy except for the length of the terms and the term limits.
Mrs. Davey.
I would echo the concern of how the vice presidency is filled. I think that we need to have a better clarity in that. Mrs. Droney alluded to it. It says the vice president fills a vacancy in the presidency, and then we should have a sentence until a special election occurs to fill it, because it doesn't say that now. So we just need to, I think we probably all are saying the same thing, but we need to memorialize it in the policy.
Mr. Carlquist?
Just try to move us along. 2:260, this is more trivial, but I'm concerned with the ability to keep current policy where there are requirements or expectations of the superintendent to insert names and addresses and telephone numbers of the complaint manager and various roles on an annual basis. I think we ought to, wherever we can, try to make the policy be as timeless as possible and have, define the role or have the position explicit in policy, but be able to have a cross-reference somewhere. Otherwise, unless this is a statutory mandate, then it's a statutory mandate to have this language. It's not I don't believe a statutory mandate to explicitly reference who the non-discriminatory coordinator is.
Actually, it is.
Is it? All right. Well, then if it's statutory, then keep it.
Mrs. Davy?
Continuing on some other issues that I noted in Section 2, I just want a clarification. Policy 2:170. We had a note to ask Andrea about that one. Was it resolved if what the change was or wasn't on that policy?
It was resolved. The concern was that based on current case law, there were specific professional services that were indicated in the policy. Specifically, if I remember correctly, I can look back, but architectural services, there was a very small list, and our board determined that we would like to have it cover all professional services. So the change was we are broadening it so that we are covering all professional services.
Okay, I just wanted to make sure we had checked on that. And then going on to 2:200, types of Board of Education meetings. I have a note that, Maria, you were going to verify if the special meeting required 24-hour personal notice. That was in the policy, and I wanted to circle back and see if we got a ruling on that.
While I'm looking, can I say I'm looking forward to electronic copies of this? Mrs. Walsh, do you recall, I know that we had resolved this.
Where's that one? It's in the section related to special meetings, and I have it crossed out as well, but I also wrote, Maria will verify if this is required or not. We didn't want to cross it out if there was some legal requirement that we provide that type of notice.
The piece that we were able to delete was the expression at the end of it, which was, or by personal service at least 24 hours before the meeting. That was resolved.
Going to do by personal service? Under special meetings?
That was what we had indicated, yes. I will comment on this from just a procedural standpoint. It's been the practice of the board that, a special meeting is called by the president or any three members of the Board of Education. In this district, we run our board meetings through board docs and through notification publicly. Even in the case of having a special meeting, this is a special meeting. We've had emergency meetings, a little over a year ago, where notice was able to be provided, I believe, at least 48-hour minimum. Also, in this electronic age, we also use electronic mail and many other mechanisms to reach out to board members. I don't know of an instance where we have not been able to reach a board member. as well as providing information to the press about a meeting that we needed to schedule at, an emergency meeting. So the personal services was removed.
If I could follow through the next paragraph, posting on the district website, I have that we crossed out the last 6 words until the regular meeting is concluded, and it's showing up in our draft. So does anybody have that reference that we crossed that out? No? Policy 200. Okay. Okay, then I must have just crossed.
Mrs. Deroni, and maybe you're going to get there. I just wanted to understand what your concern was on the piece that was deleted, or are you okay with this policy?
No, I think we should have in there that if we're going, in the policy, special meetings may be called by the president or any 3 members by giving notice thereof in writing, stating the time, place, whatever. The writing part, that's so archaic compared to how we do things now. I don't know, we want to revisit that. The purpose of the meeting to remaining board members by mail or by personal service, at least 24 hours in advance. I mean, if you really are calling a special meeting, you've got to do your darndest to let everybody know that you're having a special meeting. And maybe you need to use personal service if you can't reach people.
I think that we looked at that not as being a special meeting, as being an emergency meeting where you didn't have time for notification. And that is more general language. So I guess I'm not sure.
It is, but you've got to protect the future and boards trying to do shenanigans with special meetings, too. I mean, luckily, since I've been on the board, there's never been a board like that. We've all been above board and had no agendas and, but I think the policy manual is there to make sure that doesn't happen, that boards can't hijack special meetings if they want to.
Okay, I guess I would look for other opinions from the board. If adding this back resolves it, are there reservations about it? How strongly do we feel about the absence or inclusion of that? Mr. Collin.
I just want to, Susan, your definition of personal service. To me, that means a messenger comes to your door and leaves a package. Is that, I mean, I just think if somebody wants to get a hold of me, rather than leaving a package at my front door, they're far more likely to get a hold of me either by email or leaving me a message on my cell phone. Far more effective than hiring someone to show up at my door.
Then I think we need language that states that, somehow updated. I agree, personal service is an old term, but to me, 48 hours before the meeting, I don't know. By mail, 48 hours before the meeting, you might not even get it. If you mail something 48 hours before you want to have a meeting, didn't hear about it? Too bad.
What if we just change it to personal contact?
That might work.
I mean, and that's a much broader term, which would include a phone call, right? Or an email that was verified.
But because the reality is we don't get packages at all anymore, that we've gone electronic, and that was a cost and resource strain on the district that we've tried to move away from. So I guess a consensus, if we were to add some language in here regarding contact, personal contact. So I guess again, devil's advocate on that, so you can't reach them. How do you know when contact has been made? Personal service says, I delivered this package to this door at this time. If you post it on board docs, that doesn't guarantee that you've notified. Mr. Collins.
Should we be specific and say voicemail via cell phone, voicemail via home phone, and in addition to that, email? I mean, should we be specific, and as technology changes, refer that to the policy committee and change it as technology progresses? I think that's more specific than personal service. I think that just in a dysfunction. I mean, I think we're writing this for God forbid we ever have a severely dysfunctional board that is trying to pull one over on a few board members, how do we best?
Mr. Crowcliffe.
Just kind of throwing out, we're brainstorming here a little bit. I think the spirit of what we're trying to express here is an effort is made, a reasonable and appropriate effort is made to contact a board member to notify of a meeting, right? And I think you've given an example that says, perhaps for you or for me, a phone mail or a cell call or an email or a tweet or a text, might be the best way. But there have been others who have said, I want the packet to show up on the front porch if it's, the messenger. So what if we were to incorporate just some language that puts the responsibility on the board member to identify, here's my contact. If you want to get a hold of me, it's an emergency, and we're on record as saying, here's my mode of communications of contact. It's email, it's this cell phone number, so that it's a shared responsibility between the district office or the president who's calling the meeting and the board member to provide that conduit of communication to ensure that the effective connection is made. So what I'm suggesting would be maybe it's a little more generic language that says by 48 hours, by the manner identified by the board member. So either use this email, because look, how many email addresses do you have? Well, I sent it to this email, right? Or which cell phone number to call, or which. So I think if we put the responsibility on the board member to say, when you're part of your board, here's my contact in an emergency for a meeting. This is the way to connect.
Ms. Hirsch.
The one thing that I will say, I appreciate where you're trying to go with this, but I think in policy, I would prefer to see us leave it. I think there's some inherent value in indicating that this notice is in writing, and it is communicating the time, the place, the purpose of the meeting. I think, there's dispute whether or not a voicemail message or whether you didn't tell me exactly if there's a voice, cell phone conversation where the meeting was, where the topic was. I didn't understand that was the topic of the meeting. You didn't include that complete information. I think in the best interest of the board, I think in writing is important, and I think including the information that's there, and I would prefer us not to dilute the vehicle that's used
So is mail
to communicate.
Snail mail or email?
In my home, as a board member, I provide to the administration my home address, and I provide my home number, my work number, my cell number. The administration has many different ways to get a hold of me, but I believe that in this case, I would say, it's in writing. If it's an email and it's followed up as a package to my home, I have every obligation as a board member to check my mail on a regular basis anyway. I think that's part of your board responsibility, is to maintain communication with the administration. So I would prefer that we not weaken it. I say that it must be in writing. It must include these particular points. And if it need be, follow-up snail mail. If the administration and the board president cannot reach a board member and can't indicate that they're going to be present at a meeting, then an appropriate follow-through is to mail it to their home. That's just my opinion. I prefer not to start getting into, which email address. Everyone is assigned a board email address, and that is the appropriate communication. In fact, in terms of FOIA and all sorts of laws, all board business should take place on the board email.
I guess the one disagreement I have with that is not every piece of board communication goes through email, nor is it appropriate to do that. So, I think that we do need to look at, you might have packages that you can't even send through email. So, I guess I'm hearing that we still have some more work to do on this. Mr. Collins.
I like Mr. Carlquist's suggestion that each board member be responsible for specifying to the appropriate person in the administration what their preferred method for emergency communication for a meeting like this would be. Yeah.
Oh, okay, so we're putting this as so for this specific item 2:200, I have one open item, and that's specifically relating to the special meetings. Yes, Dr. Krizik.
purposes of confidentiality, though, I really don't think board members should have the option of specifying a personal email address. I agree with Mrs. Hirsch in that if, I can't imagine any superintendent having a meeting posted without making sure they're notifying every member of the board, whether it's using Alert Now, whatever we're going to use. So operationally, I don't see this as an issue. But I don't think putting the superintendent in a position of having to make an ethical judgment about sending confidential email to a personal email should be put into policy. That I think anything that's confidential, should either is put to board docs and it's encrypted, or and so we can send you there and say, please go to board docs, there's an encrypted document, or please check your email. There's texting, there's everything, and I think there's so many technological means by which to get hold of everybody, that I just want to caution against specifying the type, because if it crosses over into the email, then I think we're compromising some issues.
I'm sorry, the reason I brought this up in part is it just wasn't clear. I heard email being used synonymously with mail, and I was just trying to get clarity. What is it that we mean? Are we intending for that to be synonymous? If not, then let's render it explicit here.
Mr. Collins.
But you can send a whatever that board members say it's their cell phone. You can leave them a voice message that says, please check board docs. We're having a special meeting in 48 hours.
Mrs. Conn.
I think that's appropriate protocol for the superintendent, and I think that we've seen that in the past. In the time I've been on the board, there's never been an issue with contacting a board member. I think we all take our responsibility as board members pretty seriously, and part of that responsibility is to check your email. If one of us is out of town on business or not going to be available, I think we let the superintendent know that. So I don't think that belongs in policy. I think it should be done through our board email.
Mr. Collins.
Yeah, I'm sorry. As a practical matter, when I'm on the road for business, it is, in most circumstances, either extremely difficult or impossible for me to check board email because I just don't have the capacity to do that. I don't travel with a laptop. I travel with a BlackBerry. And I can't reasonably get onto the website. So a voicemail or an email to my work email address is just saying, please check board docs, we're having a special meeting, would be infinitely helpful to me.
Right, and I think that that's a procedure that the superintendent, just follows.
Okay,
I mean, that's done, but I don't think it belongs in policy.
Clearly not resolution. I think we're going to use that timer over there. When we hit yellow, we know that we're closing it up, and on red, we move to the next agenda item. I'll let you know if we have to go there. So what I'm saying is we're going to table this. We have to work on that topic. Mrs. Deroni.
On this same policy, there's a sentence that's redundant in the first paragraph and the third paragraph. All meetings are held in a time and place convenient to the public. It's a great sentence. We got to have it. We don't need it twice. It's in the third paragraph as well. Meetings of the Board of Education shall be held at times and places convenient to the public. The sentence right before that, under regular meetings, says that the board announces the time and place for its regular meetings at the beginning of each calendar year. I believe we do that at the beginning of each fiscal year or each board year, or when do we do that? It's not a calendar year, I don't think, is it?
So you're correct. We do it.
So we need to change that as well if we're going to revisit this one.
Mr. Crow.
If I can stray from that policy to it and move us on, minor one, but I think it should be captured, 2:150, which is committees. This policy draft states some of the specific standing committees. There may be others, but just one that caught my attention that I think is conspicuous by its absence is the Intergovernmental Committee. This board has talked a lot about the importance of fostering intergovernmental relations. We have an intergovernmental committee. It doesn't fit the definition that's in this draft policy of a special board committee because it's not something that gets dissolved after presenting a final report. It is something that I think fits the nature of these other committees. And again, there may be others, but this is one that I think is an important one, is a real one, and therefore we should consider including it here.
Ms. Hirsch?
Actually, in the context, Mr. Karkos, I agree with you. We have standing committees. We also have other assignments, such as the representative to SASAD. We've got a number of things that don't fall under this particular policy. In the case of the Intergovernmental Committee, the intention of this policy is that this is addressing policies that are subgroups of this board of 7, and 8, including the superintendent.
Right.
And so the intention is really to address committees that this board chooses to impanel and assign to research specific topics. The policy committee is a standing committee. The other 2 are actually statutory. And so the idea that the reason the intergovernmental agreement or committee is not there because it includes members of the city council, members of the park board, and it's not governed by this particular board. It's an advisory committee.
I hear what you're saying, but I have a little different point of view on this. One is, I think the other examples that you gave are in fact representations from this board to organizations in each of those cases, be it Lisadro, Special Education Group, LEND, and so on. Those are individuals who represent the board and play a role. In this case, we assign or ask, the president assigns 2 members of the Board of Education. So right there, we have a committee. And I think by things like state statutes as far as keeping of minutes, of Open Meetings Act, all those sorts of things come into play when you have more than one member of this board of 7. That's one. 2, it more than just kind of making sure that in policy we're conforming to the letter of the law and all. I think our policy ought to be as much about stating what we think is important. And if sending a subcommittee of this board to an intergovernmental meeting is something that we value and is important, we ought to call that out in policy. And I don't know why we wouldn't do that.
Mr. Kralquist, the only hesitation I can see with that is we control whether there's a policy committee within our own authority. An intergovernmental committee, although we may value participating on one, if the other intergovernmental agencies aren't interested in a year having it, that's something that our policy can't control. So that, I guess, is being devil's advocate is probably the one hesitation I would have with that. Mrs. Duroni.
The other question I have about this policy is that special committees may be created for specific purposes. We don't say by whom. Does the board president create these? Does the board create these? And the standing committees as well. Our old policy had that the president can appoint special or ad hoc committees. Or the Board of Education, upon majority vote, may direct the president to establish standing committees or appoints. But I mean, we're silent on that topic, and I think we should say something about it.
But by definition, this being under Board of Education, doesn't this address the Board of Education committees? I thought somewhere in the superintendent information we talked about the committees that the superintendent could form.
I'm just going to point out 2 committees, the Parent-Teacher Advisory Committee and the Behavioral Intervention Committees. Those are district-required committees. That doesn't necessarily mean, it doesn't even infer that board members will be participating on those committees. They're legally required committees. And, when you look at what's defined by the Parent-Teacher Advisory Committee, its members are parents and guardians and teachers and may include persons whose expertise is needed. So of these 3 that are listed, and I don't have the notes in front of me how we organize this. In general, the administration oversees the population of the Parent-Teacher Advisory Committee. I said oversees, doesn't, and the Behavioral Interventions Committee, although it probably falls under the Assistant Superintendent for Student Services responsibility to, have implementation. So I just need to point out that those are two legally required committees. And now it's under the Board of Education because that's how IESB put it together. And this is a policy, 2:150 is one of the statutorily legally required policies to have. So I don't know how much we can certainly add maybe, but there are requirements contained within this policy. I actually think Mr. Carlquist's comment, the Intergovernmental Committee and the Policy Committee, I don't want to say they're the same, but they're the same. They're different. They're made up of board members. They're representing board members. And those two are different than the Parent, Teacher, and Behavioral Interventions Committee. So maybe that 2 and 3 get separated out. But so out of just what I heard Mr. Carlquist say, the Intergovernmental Committee is a standing committee. It's not an appointment to an agency. It's a committee. And that committee has a responsibility for bringing back information and so on and so forth. But just wanted to comment that maybe we need to just reorganize this structurally because 2 and 3 are very different from the policy committee.
Mrs. Davy?
If I could just add to Mrs. Deroney's concern about in special board committees how they're formed. In the first paragraph, it states that the board president makes all board committee appointments unless specifically stated otherwise. So I think that statement answers. You don't think it does?
No, that says that the board president makes the appointments to the committee. It doesn't say who. This policy to me says that only the Board of Education can establish committees. Our old policy said that the president could establish committees as well as appoint people to them. And that's a change. I don't know if we want that change, but
Okay, I apologize for that disruption. I lost power, and I need power to be able to look up online. Mrs. Davy, you indicated that you had other policies that you would like to address.
I think mine are I have two quick ones. In policy 2:100, I have in my notes that we were going to add a cross-reference to 4:30. Does anybody else have that note? And 4:30 is free and reduced price food service. I'm sorry, it's revenues and investments. Okay, so Ellen's nodding. So we need to add that cross-reference there.
Thank you.
And then do you want me to go on? I just had one more. In policy 2:220. Let me get there. I have that we had a few word changes in, let me get to it. If the verbatim reporting of closed minutes, which is on the second page, I have that we had stricken in the second sentence, if neither is present, officer may assume. And that wasn't made, those changes weren't made. Does anybody else share those notes?
Mrs. Walsh is indicating that we missed that, so thank you.
Okay.
I will say if we're going to address 2:110, consistent with that, we need to address 2:210 because that talks about when the timing of when the officers are elected, and so I think we need to match those up concurrently. I would also ask, and this was another item that was brought forth from the community, but 2:140, what this policy does is and this is communications to and from the board, it sort of merges all communications into one bucket. So we don't really distinguish to say if you have a question about, whatever, a teacher or a bus route or whatever, what kinds of communications would be more appropriately directed to the superintendent. It really directs everything to that. And in our current policy, we sort of distinguish between matters that might be directed as representatives of the community to the Board of Education directly, and those matters that would be directed more appropriately through the superintendent, or if you send it to the board, that's where we're going to direct it, because that's where the problem resolution would exist. So I guess I would just say on this one, I think maybe the merging of those two into one, we sort of lose the fact that there might be two different separate and distinct types of things that might be communicated.
If I could comment on this policy as well, I think that we didn't necessarily capture the will of the board to communicate and engage with the community, and we didn't really provide information about, at least in this portion of the policy manual, about the many different ways that we do communicate with the community and that we do hear from the community, and we encourage that kind of communication, whether it's through committees that are formed, whether it's through soliciting feedback, for instance, on the budget cuts, where we ask for and solicit specific feedback on a particular current issue like the budget, or this policy manual adoption in and of itself. And I think the board is interested in hearing directly from the public, and I don't know that this policy as it's currently written reflects that wish. So I agree with Mrs. Ostojic that we could do a better job of delineating. There are different types of communication. The board is interested, or at least I'm speaking from my point of view, the board is interested in obviously communicating with the community members that we represent. There are specific questions that come up that would be appropriately handled by a board member in terms of answering an explanatory question, or there could be a communication that would be directed to the administration and should go to the correct administrator. And I think we need to be a little more explicit in giving some guidance in terms of what's appropriate, what's the best way to communicate with the board and to get a question answered.
Mr. Collins.
There is also an opportunity to delineate further in section 8.10, community relations.
Want to give some more specifics about your interest on that policy?
My only point is I think we should be careful to, as we delineate the different types of communications, to just put them in the right spot.
Why don't we cross-reference it? Can we cross-reference 8:10
Sure.
with this policy? Does that add something?
Are you trying to get us to finish up on 2 and jump to 8? It was wishful thought.
I think sticking with policy 2 at this point, we should reference 8 and at least connect the dots on those. And at this point, I am going to make a pause. Mr. Kralquist expressed a concern earlier as far as we're crossing between old policy and new policy. We started this with a motion to discuss the process of the first reading. We are not, I think there's substantial things that are going to need additional work on this. So what I would suggest is we can continue our work through the policy manual, but that we don't, that I would ask the motion maker to withdraw the motion to approve the first reading, because for 2 reasons. Number one, the movement between the 2 sets of policy manuals, and the other, that we're not knocking a whole lot off of here. I think that there's a little bit more work of substance for us before we come back with this. So I guess I would ask the motion maker if he would...
After observing our progress this evening, the motion maker withdraws the motion.
Okay, and now I believe I need to have the seconder agree to that. Okay, so the motion is off the table. However, we're going to continue with our work. So I know Mr. Collins was jumping to Section 8, which would be great if we were there, but we're going to stick. Are there any other items in Section 2, Mr. Kralquist?
Well, I didn't want to leave 2140 yet. Is 2140 something that you're suggesting put on the parking lot to continue to refine in the top half, whether it be explicitly state the communication? Because what I also don't want to get lost here is it's a delicate balance between, and I think the reason it's in our meetings it was drafted like this was to be clear, not to have the board appear as if it was disinterested in receiving direct contact, because but it was to be clear to say not only where the appropriate communication should be and to have the most efficient. Board members don't always check their email as regularly, for example, as the administration, and sometimes the timeliness. And oftentimes, a member of the public thinks that the board is the right place to go, and it may not be. So that I think does need to be reworked. The other pieces in the lower half. And whether this requires a change, a subtle change in language, or just to make sure that this is what we're intending. This is specifically use of electronic communications, and it says email. I think the intent here is that there is not board deliberation in email amongst multiple members of the Board of Education. But I'm concerned that someone could misconstrue this to say that email by a board member in their capacity as board member, singular, is either to individual responses to the public or to another board member is inappropriate, and I don't think that's what we are trying to communicate. As has been stated, there should be a collegial exchange, but there should not be deliberation, there should not be multiple CCs, there should not be forwarding. There's all sorts of elements of practice that need to be adhered to. But if I were to send an email to Mr. Collins, and he and I are engaging in a conversation, that is not prohibited by either the Open Meetings Act or Freedom of Information. It's foiable. It's not prohibited by Freedom of Information Act, and it is incumbent upon each of us as individual board members to make sure that policy and that statute is not violated by having others engage in that communication. But that kind of communication is not or should not be prohibited. So if in fact our interpretation is because this is plural, it says board member use, but then it says among board members. My interpretation is, I just want to be clear that this is the broad understanding. When it says among board members, it is talking about more than two, or two is plural.
I read this as two. Ms. Hirsch?
Again, the source for this particular policy, I believe it's actually, I'm checking it word for word, is the IASB recommended policy. And this is one that I would want to be very careful with and ensure that the way that it's read, I think board members all understand the limitations that are placed upon us due to the Open Meetings Act and what the intention of the act is. And we understand the implications of FOIA and discussing district business, for instance, on personal computers that are not board email, those kind of things. So I would caution us in making changes to this particular policy based on a concern of making sure that we're not opening ourselves up to risk.
But I don't disagree with that. But the reverse of that is true as well. Mrs. Conroy sent an email and said, "Here's my point of view," or "Have we thought about this?" If she sends that email, is that a breach of this policy by sending that email to multiple board members with a point of view? It's not a discussion, it's not deliberation, but it's the first time, if she's the first person to weigh in on that. Or if she decides to send a point of view to an individual board member via email, is that a violation of this? So I think we just want to be precise with our wording to make sure that as a form of communication, we are not prohibiting the use of email, but we are being very clear that Freedom of Information, Open Meetings Act is being respected and strictly adhered to in our communications.
My reading of this and the placement of this policy in the policy manual And maybe we need to tweak the title of communications to and from the board. I think that's probably not the best title for us to choose in terms of trying to communicate what the intent of this policy is. My reading of this policy is that the intention of this is communication amongst board members, and that's why we're talking about specifically electronic mail and being in compliance with open meetings and not discussing board business. The intention is to discuss board business at the table. That's what we do, is we address board business at the table. And so we can come back and revisit this, but I would like to be very careful and make sure that this is very cleanly written so that it's clear that this is talking about, or the intention of what this policy is about. I think community relations and communicating with community members should be all covered in Section 8. The entire section is dedicated to community involvement and communications with the community, and that's where I think it's appropriate to have those clarifications.
I know that we're going to address this, and so I'm going to table this piece of it, but I do think the intent isn't to say we don't want board discussion in email. It's against the Open Meeting Act. It's violation of what we're supposed to represent at this table. So where's the line between that and if, I'm an angry board member and I think that there's something that I needed to share, an individual statement, that's not a discussion. So that's not a debate. It might be a debate in that, I don't know. I guess if we're narrowing that an individual board member can't send a communication, we shouldn't be responding, and I think we're very careful about that. We don't want debate to happen in email, but if we're narrowing this too much, I guess is really what. And again, we're going based upon the guidelines that have been recommended to us. This is the template that's being provided to all the school districts. And my understanding in this process is, Andrea really thought that 4 meetings this would be done. So many districts are taking this stuff boilerplate. They're not doing anything to it. But I guess that as part of addressing this, I just want to make sure that we're not being too narrow on this. All right, we're going to keep moving. We're going to get through Section 2 if it kills us. Any other items that board members would like to address in Section 2? Mrs. Deroni.
Can we take out these exhibits to 140E? I mean, these are the exhibits that say board members are permitted to provide information to each other. Board member can discuss with another board member in email, on the phone. But I don't think exhibits belong in there. If we want to take some of that and incorporate it into the policy, fine, but I don't think exhibits belong in the policy manual.
Can we agree to that? This will be our first one tonight, that we're going to take some of this substance and maybe see if we can edit the language from the first one? Check one off the list.
Actually, I would like to see if we can come to agreement that all exhibits will be removed from the policy manual. The intention is to provide some education and some background. I think they were provided originally to help give board members some context and to look at what the procedures are going to be that are going to be supporting these. So I think, are we okay on removing all exhibits from the policy manual?
I would also suggest that there's way too much left in Chapter 2, and in deference to the staff, I think we should wrap this up. I mean, we're not going to finish. Well, we're not going to finish. So what's the magic between the middle of Chapter 2?
Here's my question. I guess I'd like to get a quick list of what we have open in Section 2. What other policies we'd like to see addressed?
I have, I think there was more in 2110, but we're already going to revisit that. Okay. 220. It's going to take a while. We're going to get rid of 220E. That's an exhibit. We're getting rid of that. Okay. 230 we've already talked about, but I have an addition to that. 240. I've got things to say about that, and then the exhibits we're going to get rid of. And that's it for me.
Okay, can we hear the concerns on 2240? Because I know that we've addressed those other policies, but we have not yet addressed that policy.
2240 speaks to policy adoption, and I think it doesn't talk about first and second readings. It doesn't talk about needing a supermajority, and I think all of those things are good elements from our old policy that belong in our new policy. Just to elaborate, if you want to get into it, I don't think this is the time, but I think that requiring 5 out of 7 board members to make a change in policy is a careful, deliberate, thoughtful thing for a board to have to do, and takes a lot of the politics out of changing policies. I just think that you can be flip-flopping with the policy manual if you go with a simple majority to do that.
Just as background, we did have extensive conversation around this particular policy, and we did make changes to it. So the entire board has reviewed this policy. If I remember correctly, part of the discussion in terms of the supermajority, it was discussed, and I thought agreed at the time, that the will of the board is the will of the board. And whether it's a simple majority of 4, it's a supermajority of 5, or an absolute, 6 or 7 board members that are in agreement, that we felt as though that when the board speaks, we speak with one voice. And so if there was 4 board members that would like to see a revision, remove a policy or add a policy, that was what was going to rule the day.
Mrs. Ostojic, what I'd like to add to this is, I think this is important not to get lost. I missed this meeting, okay, and because I missed the meeting, I think we had personal business things that we were not able to be at every one of these 17 meetings. I wasn't able to be a part of that discussion, and so this is the first opportunity that I'm having to be a part of that discussion. Just to make a statement that we've already discussed this, and this is the will of the board. I think we're really missing the opportunity of what this whole process really is for. It's for all of us to have a final, opportunity to weigh in. And I think that policy is the main work of the board. And to say that we speak with one voice, I think that policy is so important that having the supermajority is appropriate and was there for a reason in old policy. And so for the first time, am being able to say that I think that we need to revisit this and look at making it a supermajority.
Mr. Carlquist.
I share some of these sentiments, especially, again, the policy that, past policy calls for first reading and second reading. I mean, that is in part to permit deliberation and review and input from the public, but it's also, I think, for board members to go through and benefit from the value of this kind of collaborative deliberation and discussion, and end up with better, stronger policy. So one is specific to policy 2240. I think we need to have some discussion to say, can we strengthen this, can we improve it, to include your perspective. You weren't there, we should have the benefit of your perspective. Similarly, I think we've been through so many of these policies, and there's interrelationships. I think it's okay that as a board we maybe are open to and willing to listen to others and maybe shift our position somewhat. And then lastly, I also want to, I think Mrs. Durant, you brought up, be sensitive to staff, but also to board members. We're going at this now about almost 4 hours now tonight as well. I don't want the quality of our work to diminish as we kind of keep grinding on this. So we have a good parking lot. By the way, just my opinion for what it's worth. I think the items we've discussed tonight and the items that we've identified that need some work in terms of some language, but I think we as a group pretty much discussed what the essence of those policy revisions or enhancements should be. I think we're making for better policy, in addition to public input that we received. So I'm hopeful that we can continue on this journey and do this in a quality way, recognizing that there still is a sense of urgency, which is to get the job in. But with all that, I hesitate doing this, but I'd like to move that we adjourn for the evening. but I, as I said, I'd like to. I'll give you, Mrs. Ostajek, a chance to react, and then we can do that.
I'm going to make a comment. We do have an action coming out of closed session that we need to address tonight. I guess here's what I'd like to say. We've spent a tremendous amount of time on this. The policy committee and Ms. Hirsch, again, you behind the scenes, I know you've done a lot to orchestrate this, and it is frustrating because we want to get this done, but policy are the guiding principles of the district, so this needs to be a thoughtful process. I think our hopes with the 17-plus meetings we've had is that we got pretty much there. Obviously, we have a little bit more work to do, so I guess I'm going to recommend that we try to schedule one. I mean, I think 2 was a big section. 1 to 2 more meetings as a group to get through the remaining open things and identify, and hopefully we can be resolving things that are going back and forth before we take this out for adoption. I'd like to move forward on, we do have an action coming out of closed session. Mr. Carlquist.
Madam President, I move that the Board of Education approve the negotiated agreement for the period of July 1st, 2010 through July 30th, 2013 between the Elmhurst Community School District 205 and Local 571, Elmhurst paraprofessionals and school-related personnel.
Okay, we have a motion by Mr. Carlquist, seconded by Mrs. Conroy. I'll open up for board discussion. I just would like to make a comment. We have had this process going underway for a significant amount of time, and I would like to just thank the negotiating team, both on behalf of the PSRP union and the district, and board representation that did so much hard work on this. And I would like to acknowledge appreciation for the PSRP staff. They came back to work this year, continuing service to our students without a contract in place as a gesture of goodwill, knowing that we were moving along and making good progress on it. And I think that this contract, it's a fair contract. It balances the resources and interests of the district with those of the PSRP union. So I just wanted to acknowledge that. Are there any other board discussion items? Mr. Carlquist.
Yes, thank you, Madam President. As the motion maker, I was going to, and you did a very good job, express some of the same sentiments, which was to express appreciation to the negotiating teams on both sides to get to an agreement. Each group works diligently to represent the interests and the needs of their respective constituencies, and to be able to reach an agreement like this and have done so in such a productive way, I think the teams on both sides really need to be thanked. Secondly is really a question for Dr. Krizik. Dr. Krizik, will there be communications made available to the press or the public that summarizes the terms of the agreement? The motion simply indicates that the negotiated agreement can or will. I'd like to see some summarization made available.
I'm going to say a quick thank you for that. We appreciate your work on getting that all keyed up and ready to go. Mrs. Davey?
I would just like to probably end this discussion by saying that I had the privilege of being a part of a team that worked on this contract, and it was we utilized the interspace bargaining process, and what that allowed both teams to do is come together as one team and in a very collaborative effort work together for what was in the best interest of our district. And I'm very appreciative for everyone that served on the teams and for giving me the opportunity to work with everyone and come to a satisfactory contract that's it's good for the district and it's good for everyone that was involved in it. So I just want to say thank you.
Thank you. Mrs. Walsh, can you please call the roll?
Mr. Carlquist?
Aye.
Ms. Davey?
Yes.
Ms. Hirsch?
Yes.
Mr. Collins?
Yes.
Mrs. Ostajek?
Yes.
Ms. Conroy?
Yes.
Mrs. Droney?
Yes.
7 ayes, no nays, that motion carries. I do want to also thank Ellen Walsh, the other Ellen Walsh, for being here long beyond your duties. We appreciate your support. You've been a tremendous resource to us through this process, too. So thank you for staying late. I know you rather would have been somewhere else. We have 2 upcoming meetings scheduled. Yeah, 17 different nights, right. Tuesday, September 14th, we have our Board of Education workshop meeting, and again, that's 7:30 right here at the District 205 Center. Tuesday, September 28th, we have our Board of Education business meeting, again, 7:30 here. Are there any board communications? Seeing none, I will accept a motion to adjourn. Mr. Carlquist, motion maker. Mrs. Conroy is a second. All in favor? Those opposed? That motion carries.